Good morning. We're going to wrap up Chapter 5, Legal Liability. The good news is nothing on this presentation today will be on the test. It's just for background and perspective, and it's all about timing. We had a very, very successful person speak one year, and he talked about how fortunate he was that his timing was always spot on. I had a lawyer, he was a general counsel for Ernst & Young many years ago, speak to teach the class on legal liability. And his presentation and perspective were entirely different than mine, better, I'm sure. But he pointed out, he says, look at the three classic cases, 1931, Ultramaris, 68, Rush Factors, 83, Rosenblum. And he says, look at the world in 1931, 1968, and 1983. So in 1931, we were in the throes of the Great Depression. Anything that stymied commerce or might destroy jobs was bad. So the courts tended to rule in favor of business and less in favor of individuals. In 68, personal freedoms were greatly enhanced, and so the courts became more attuned to individuals and maybe less attuned to businesses, accounting firms. 83, that trend continued. California in 1986 had a case, International Mortgage, and it was the California courts at that time said that auditors should be liable to foreseeable users for ordinary negligence. That was 1986. In 1992, Pricewaterhouse had a lawsuit with a bank in Arizona, and Arizona had never had auditor liability securities lawsuits before. So they looked to California. They didn't have any precedents of their own to look toward, so they looked at California. And in 1992, California was still following foreseeable parties. So the court in Arizona decided if it was good enough for California, it was good enough for Arizona. And they adopted the foreseeable party standard where auditors are liable to foreseeable parties for ordinary negligence. California was over here on the far right, reasonably foreseeable. That's where everybody outside of California thinks California lives, way out on the edge. But then in 1993, shortly after the Pricewaterhouse case in Arizona, the Biley case came up in California. It was Osborne Computer. It was a tech company, and Biley was an investor. And the court in 1993 decided that auditors shouldn't be liable to foreseeable users, only to foreseen parties for ordinary negligence. Now, in 1993, California was in a very, very serious recession. I remember an article from the time that Los Angeles itself had lost over 100,000 manufacturing jobs. So the courts in 1993 were not oblivious to the world around them, and they ruled to limit auditors' legal liability at least a little bit. So California moved to foreseen parties. And I would argue it's a very conservative look at foreseen parties. Things are getting better. In the last 25 or so years, every major court case, I believe, has fallen in favor of the auditors. Pricewaterhouse appealed, and they never had to pay that $338 million judgment. It cost them tens of millions of dollars. This was not trivial, but they never had to pay. They won on appeal, so that was a win. There was a federal law, Racketeer Influenced and Corrupt Practices Act, and this was a federal law. And the thing about it was treble damages. Now, the Federal Securities Act are not treble damages. They're single damages. So if an investor loses $1 million and sues under the Securities Act of 1933 or the Securities Exchange Act of 1934, they sue to recover their loss. But under the RICO laws, you could sue for treble damages. However, after a couple cases, the U.S. Supreme Court said, wait a minute, auditors are not RICO, they're not racketeers, so auditors shouldn't be subject to the racketeering law. They said racketeering requires some participation in the operation or the management of the enterprise, so RICO law, the federal RICO laws, no longer apply to auditors. That was a win for the accounting profession. The original securities laws were that auditors could be sued for aiding and abetting someone that participates in the commission of a crime. And an aider and abettor is party to the crime and may be criminally liable as a principal. Okay. So under the original securities laws, auditors could be sued for aiding and abetting, which meant they could be party to the crime. The Central Bank of Denver versus First Interstate Bank in 1994 said auditors third-party investors are no longer able to bring lawsuits against auditors for aiding and abetting. This was a big win for the accounting profession. The Private Securities Litigation Reform Act of 1995 amends the Securities Exchange Act of 1934. Again, the Securities Acts were originally written that auditors could be liable for the entire damages. So if a company sold stock, there was a $10 million loss by investors, and the company could only pay $1 million, the auditor could be on the hook for $9 million or the whole $10 million for that matter. But the Reform Act of 1995 created proportionate liability. Auditors are no longer jointly and severally liable under the Securities Act. So now the jury decides, oh gosh, the investors lost $10 million, management's 80% responsible, the board of directors is 10% responsible, and the auditors are 10% responsible. Then the auditors are only liable for 10% of the damages. A big win for the accounting profession. The Securities Litigation Uniform Standards Act of 1998. It requires that security class action suits with 50 or more parties must be filed in federal courts. This is a win for the profession. The federal courts tend to be more conservative than state courts, and they're definitely more consistent than state courts. Did you hear my puppy in the background? Well, excuse us both. So this was a win because federal courts are definitely more consistent and tend to be more conservative than state courts. The last thing is the New York State Legislature has passed legislation that defines auditors' liability, and auditors are no longer liable to foreseeable parties for ordinary negligence in New Jersey. We still teach Rosenblum even though New Jersey has overturned it because the concept is still valid in Mississippi and Wisconsin.